We're here today on an eviction suit. The grounds for this eviction is for unpaid rent, which we will get to in just a second. Next thing the court looks at is the notice to vacate, which shows to have been delivered August the 11th, 2025, and shows to have been posted to the inside of the dwelling door. Okay, Mr. Rhodes, you're shaking your head no. Unmute yourself.
Judge, this is the second time that she has supposedly put that inside my dwelling. I have ring cams, and on August the 11th, which is my birthday, she never once showed up to this house. They put a vacate inside my dwelling.
Okay, Mr. Riley, who posted the notice?
So it was not me that posted it. I believe we had someone going out to the property to look at some damages that were done with the HVAC system, and they were the ones who posted it on the inside of the dwelling door. And we also backdoored it and emailed it directly to them on August 7th. And in our records, it shows that both of them did open that email and seen that notice as well.
Mr. Rhodes, do you remember getting an email?
No, sir, not that I recall. My wife may have.
Okay. Okay, well, the good thing about, and this law just changed here recently, but you can accept it, you can deliver it by email. And but you're saying your wife may have received, but Miss Riley's testimony is that they received a response that it was received by someone.
Yes,
So
it was opened on August 7th by both of them, because it shows in our system. When we send out an email, it shows delivered, and then when they open that email, it lets us know that it's been opened. So they'll say open, but the tenant actually opened it on August 7th of 2025 at 5:08 p.m.
Okay. All right. I'll accept that, Mr. Rhodes. Do I have a copy of the lease?
You should in your documents.
Well, I got tons of documents. I'm just trying to figure out which one is which. Okay, well, let's do this the other way. Okay. Is there a lease in this case?
Yes, their lease agreement started September 1st of 2024 and it ended August 31st of 2025. They are currently on a month-to-month lease since the current lease expired and it rolls over to month-to-month.
Okay, I found the lease here. It was on the back page. And okay, so the agreed upon rent is $12.95. Is that still the same?
Yes.
Okay. Due and payable on the first day of the month and considered delinquent on the fourth day of the month, at which time late fees are incurred. And on this, I do have electronic signatures for everyone. So Mr. Rhodes, what that means is you and your wife both have to do something on a computer to affix your printed signature on the lease. Do you remember doing that?
Yes, sir.
Okay, and by doing that, you accepted the terms of the lease, and that's why we are here today. Okay, so now beginning with any partial months, Ms. Riley, which months are due now?
Months that are due now is partial July.
How much is that?
Let me get that paper. I had it right here. That's all the other stuff. And I know full months of August. So partial July is $647.50.
Okay.
August rent $12.95. And then if I may include as well September's.
Yes, you may. All right, I have a total of $3,237.50. Is that right?
That is correct.
Okay, all right. Do you have anything else?
No, based on the evidence that was submitted, I did receive a copy of it in regards to some maintenance issues that were going on at the home dealing with the HVAC service. That started on July 10th. And we on that's why you have so much evidence presented to you. We gave the tenant half off on July's rent. So the prorated part that is due is still the amount that they still owe that they didn't pay that was half off. So that's half of the rent. We credited it to them because we gave them two options due to HVAC system was leaking and the ceiling had fell in and caused a big old hole. We gave them an option, you also have this as well, that we can do a rent reduction on July's rent, give them a credit of half of July's rent, or we will let them out of their lease agreement and it'll be effective July 31st of 2025. They chose to go ahead and stay at the property. They accepted the half off on July's rent. Also email notification. We were informed that they would pay that on August 22nd and be caught up, and they failed to do so. They stated that they have on July 11th, they stated they were staying with Miss Rhodes' mother for the time being until we can get that hole and everything fixed for the HVAC system. And then they reported that they did not go back to the property until August 19th. That they were finally back in the property after all repairs and everything were concluded.
Okay.
So I wanted to make sure that that was stated in court due to the evidence that the tenants did provide. I'm not sure how what was going on in regards to the evidence that they provided. So I figured I'd just cover all bases.
Okay. All right. Anything else?
No, sir. That is it.
Okay, Mr. Rhodes, you've heard everything been presented so far. Do you have any questions of Miss Riley of anything that she presented to court?
Yeah. We asked them to help because we
Put it, man, sir, put it
Yes.
in the question form, ask her a question. And not about something else. If you want to give a defense, you're going to have that ability in just a second to give your defense, and then she can respond to that if you want. This is just, do you concede that the rent is due?
Yes, I do conceive this.
Okay,
Yes.
well then let's move forward from there. And then if you want to give your defense, if you want to tell us what's going on, you're welcome to do that now.
Okay. We were when the ceiling fell in on my wife and little girl. The HVAC people had been out there 2 days earlier, crawling through there, and it was fine. And then all of a sudden, my wife and little girl were in the room, and not the whole ceiling, but the ceiling collapsed. Hitting my wife in the ankle, and where I had me having to take her to the hospital because all the black mold that was up there caused an asthma flare up. And the evidence there that we have, there's a doctor's note from my wife's doctor stating she is not allowed to go back into this house until it was fixed correctly. It does not take them. It took them over. We were out of our home for over a month because it was one thing after another. Something to do with the contractors that said they wouldn't come back in certain days on this date and this date. We were only at my mother's house for maybe a week and a half because my mother's house was only so big. So we had to go get hotel rooms. And hotel rooms get expensive. So that's why we did not pay the rest because we, thought, because we asked for help to help us out, at least someplace else to stay. And they refused. And that's all we're asking for is for our money, all our money back. We like our house. We want to stay. but I'm not gonna sit here and argue with Candace about stuff, 'cause I don't even know who Elk Holding is. I rent from Carbajal, and that should tell you something, that if they're sending their DBA to take care of their business, this ain't the first time this has happened.
They're a leasing company, and when you sign the lease, you sign the lease with Elk Holdings Incorporated. And Elk Holdings Incorporated authorizes Carbajal to hear their cases or take care of their rental property like this. Okay? All
Okay?
right. Do you have anything else?
No, sir.
Okay. Ms. Riley said something that I wanted to ask you about. You were given the option to vacate your lease.
Yes,
And why did you not choose that option?
because we needed a place to stay once we got everything fixed. And second, it was convenient as soon as the ceiling fell that they were sending us out eviction notices and saying that asking us to vacate our lease. And that's she did ask, they did give us the option to vacate our lease.
Okay.
Right now, finding a house anywhere that's worth living in is hard to find. So that's why we agreed to keep our lease.
Okay. Well, here's the deal. The lease calls for the rent. And if you stay in the property, you're obligated to pay the rent.
Yes, sir, and I understand that, but we were not here at the property. We were gone for over a month.
It doesn't make any difference. You're still on the lease. You got a valid lease. Whether you're there or not is immaterial. I mean, I understand why you left. I understand all that. But first of all, I want you to understand a couple things. Number one, this eviction is strictly about non-payment of rent. Okay. The second thing is you cannot bring another suit in with an eviction. If you feel you have damages that are incurred, you must bring a separate suit on that, Mr. Rhodes. You cannot attach it to an eviction suit. This eviction is based solely on the non-payment of the rent. Okay.
Okay.
Okay. Now, and I will tell you this about rental property and maintenance. You as a tenant have rights as a tenant. If you keep your rent up, you have the right to file a suit against the owner for repair and remedy. But if you become delinquent in your rent, you lose that. You don't have that option. So, and that's what happened here. You got behind in rent, and that's why I hear what you're saying. I've heard everything you said, but in this suit, it's solely and strictly about non-payment of rent. I know you're telling me why you didn't pay the rent, but I'm telling you that that's not an excuse. Okay, I mean for this part. And if you still feel that you have damages incurred by the owner or the property management, then you have to file a separate suit. But you can't get a suit or you can't get a judgment out of this one. Okay. Okay. All right. Do you have anything else, Mr. Rhodes?
No, sir.
Miss Riley, do you have anything else?
No, sir.
All right. Having heard the evidence, the court finds for the plaintiff for possession of the property and for the back rent of $3,237.50. The court will also award the plaintiff the court cost in the amount of $234. Now, Mr. Rhodes, on that the rent $3,237.50, that's only rent. Your lease, I believe, calls for late fees or late payments that the court does not address. However, you did sign the lease, you and your wife both, so that's going to be between you and management. Okay. This is the judgment of the court, and the judgments will go out in the mail today, and you should get them either Monday or Tuesday. Mr. Rhodes, I want you to understand that you always have a right and to retain, a right to an appeal if you think an appeal is necessary. But again, I want you to understand this is just about rent, not about what the other issues that you brought up. Anyway, that appeal will expire on Thursday, September the 18th. If you don't appeal, don't get something worked out, then on Friday, September the 19th, you can proceed, Miss Riley, with the writ of possession if you need to. Writ of possession is the next phase of an eviction, okay? All right. I wish you well, Mr. Rhodes. I hope everything works out for you, but this is the judgment of the court, and we are adjourned. Okay? Good luck to you and your wife, and have all of you have a blessed day.